Friends, how are you? First of all, Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. Myself is Dr. Soni. I am an advocate and a defense counsel. There are multiple queries regarding the arrest and the bail. But I want to clarify that the bail is rule, jail is exception. These are not my words. The said scenario inter alia propounded by Honorable Supreme Court in Caton of Judgments. In today's class, I will discuss one of the most important and recent judgment of Honorable Apex Court, which is dated 15th of Jan 2026. In that case, to prevent the illegal arrest, certain guidelines are propounded by Honorable Supreme Court. The guidelines are: there must be justification regarding the arrest. In the routine way, the arrest could not be done. If it is going to be done, in that scenario, the arrest will be illegal. Apart from that, Honorable Supreme Court had relied on its previous judgment, that is Rajesh Kumar versus State of Bihar. Judgment specification is 2014, volume 8, SCC, page number 273. In that case as well, Honorable Apex Court specified that the power of arrest is one thing, but the exercise must be lawful and must be justified as per available facts and circumstances. If it is found that the powers are exercised in the mechanical way, in that scenario, the hearing officers would be responsible. Even the magistrate is bound to scrutinize whether arrest is as per law or it is in the mechanical way. And if it is found that it is in the mechanical way, the arrest deserves to be set aside and the accused deserves the bail. Means the liberty of the accused deserves to be restored as soon as possible. As we know that the life and liberty are the fundamental right. It could not be compressed. The process to compress must be justified by law. So, Honorable Supreme Court specified that if the arrest is going to be done, the discretion by the authority must be exercised as per the sound principle of law. And apart from that, we have to emphasize on section 35, subclause 1, subclause B of BNSS, that specifies the multiple grounds to justify the arrest. If the concerned person is going to commit or has committed the offence that is cognizable in nature in presence of police, the arrest could be done. In addition to this, if the proper investigation of the case, the investigation is sine qua non, then it could be done. But each and every time, the reasons must be on record. And apart from that, if the accused is going to cause disappearance of the evidence, or the accused is going to tamper with the evidences, in that scenario, he could be arrested. In addition to this, if there is a possibility on record that he is going to flee away from course of justice, in that scenario, he could be arrested. So basically, the process of arrest is to prevent the scenario that are specified in section 35, subclause 1, subclause B of BNSS. And apart from that, the reasons are required to be recorded as specified. If there is no justification, there are no reasons, everything is going to be done in the anxiety, in the mechanical way, in that scenario, the arrest could be declared as illegal. So whenever you are going to argue in bail, specify why your arrest is illegal and why your liberty is to be restored. Without specifying the procedural lapse on the part of police, you could not be succeeded in your bail application. And apart from that, you are bound to specify the plausible explanation to the allegations or incrimination in the FIR. In that scenario, you could increase the chance to get the bail in the consent court. So basically, we could say that the arrest must be justified as per the facts and circumstances and as per the legal compliances. And apart from that, if the punishment is up to 7 years concerning any offence, in that scenario, the police is bound to follow the process or mandate laid down in section 35, subclause 3 of BNSS. If there is any variation or the police is not going to comply with the same, in that scenario, the hearing officer would be responsible. So, simply we could say that in the routine way, in the mechanical way, the arrest could not be done. So, whenever you are going to draft the bail application, first of all, we have to emphasize why arrest is not justified. Then we have to emphasize why it is in the routine way. We could also emphasize that the arrest is mechanical or it is cyclostyle, and apart from that, there is a gross violation of guidelines of Honorable Supreme Court more specifically of section 35 subclause 3 of BNSS. So in that scenario, we could be succeeded and we could chalk out a good case for bail on the record. So I think that I have specified you the recent guidelines regarding the bail, regarding the arrest. So things are simple. Just observe them and specify them so that you could chalk out a good case for bail on record. See you in the next lecture.